All right. This is the State of New Jersey versus Taiwan Sanders Boyd under Promise 254633. Appearances of counsel.
Good morning, Your Honor. Assistant Prosecutor Katie McGee on behalf of the state.
Good morning, Your Honor. Charles O'Connell on behalf of Taiwan Spence Boyd, who is present seated to my right. Also assisting me today is my investigator, Farah.
All right.
I can never pronounce her last name. I try.
You need to fix that. Good morning.
Good morning.
And we're here to address the state's motion to detain Mr. Sanders Boyd. I will hear first from the state regarding probable cause.
Yes, Your Honor. Discovery has been provided to counsel. Just by way of background, the defendant is an individual who works at the 7-Eleven in New Brunswick here in Middlesex County on George Street. This incident occurred on Tuesday, 9/30/2025. The Brunswick Police Department received a 911 call for a medical emergency at the 7-Eleven. For the record, this defendant was the 911 caller. However, he did provide a false name. It's my understanding that he did provide a false name originally to police officers. And then he indicated when they arrived on scene that he had pushed the victim, and he fell back and hit his head, and that's how this injury occurred. We did subsequently receive and download surveillance footage which shows the altercation, Judge. I will let you know that the altercation occurs in two parts, and I have the timestamps broken down. Again, this has been provided to Mr. O'Connell. So I'm going to play, if it's okay with Your Honor, the first altercation, which occurs at approximately 1:33:48 in the morning on the 30th of September. You're going to see the defendant in black standing behind the counter because he's working at the 7-Eleven, and the victim in white, a white t-shirt, and he has a sling. One of his arms is in a sling. So if I could just share, if Your Honor is able to see that.
I am.
Video, and I will get it playing. And again, Judge, for the record, the white, that's the
Yes.
victim, and this is the defendant. Thank you, Your Honor. There is no sound either, Judge.
Is the other individual an officer of some kind? It looks like he has a badge on.
He's a security officer
He's actually a
for
security
Rutgers.
guard for Rutgers
Okay.
University. And he leaves prior to the punches being thrown, Judge. So, Your Honor, at this point, the victim has passed out and he's on the floor, and that's at approximately 1:34:40 in the morning. If Your Honor could just pull up the next one, Judge. Are you able to see this one, Your Honor?
Not yet. I can see it now.
Now, just for the record, Judge, the timestamp on this one begins at 1:37:10, so approximately 3 minutes later. Again, the victim is in the white and the defendant is in the black. Your Honor, it's after that. I'm just going to stop the share right there. Thank you, Judge, for your indulgence, court's indulgence, but I felt the video is better than just me telling you what happened. As they say, a picture is worth 1,000 words. After that second punch, the victim goes down, and he actually suffered a skull fracture and brain bleed, which ultimately resulted in his death and these charges for the reckless manslaughter, Your Honor. So there were several witness statements that were taken also that were provided to counsel and discovery, and we believe that satisfies probable cause, Your Honor.
Thank you. Mr. O'Connell, your position on probable cause?
Judge, I would stipulate the probable cause, however, I do dispute some of the factual allegations made by Ms. McGee. I was not able to hear the 911 calls or the review of the body. Well, I was able to see the body cams, but not the 911 call. When the first officers respond to, my client did call 911. The police officers responded. The first police officer asked my client what occurred. He told him in detail what had occurred. The police officer, I think, due to the normal chaos of a scene like that and dealing with multiple issues, only heard portions of it, that the victim went down and was unconscious. He came back later to clarify, and my client told him the same recitation of facts again, that the altercation between them began as verbal, became physical, and that the victim fell. So I would stipulate as a probable cause, Judge.
Thank you. So probable cause is established. I'll hear from the state as to why he should be detained.
Thank you, Your Honor. We filed under the two-prong approach here, Judge. First and foremost, I do believe that the defendant is a danger to the community. While I recognize that this was not a case where weapons were used, this is a punch case. That's why it was charged as a reckless manslaughter and not an aggravated manslaughter or a murder in the first degree, Your Honor. There is clearly reckless behavior that was done and violence that was done unprovoked. And while I understand there was a physical argument, the videos show that our victim never gets a punch in. He has his arm in a sling. He's knocked out once. There's still obviously verbal argument that's going on, but I believe the second video shows the fact that the defendant clearly has no impulse control and is a danger to the community, particularly working in this public setting where he's encountering people on the regular. Obviously, the defendant is annoying. He won't leave. They want him to move from the register, but you don't take those kinds of matters into your own hands. That second video shows you that the defendant is even, at some points, it looks like, it appears to the state, Your Honor, obviously it's up to your interpretation, he's saying, hit me, hit me. He's antagonizing this violence, Judge. And he had no problem calling 911 when the victim went down and is knocked out cold because he has a bleeding brain and a skull fracture. But he could have called 911 and the police to remove him from the 7-Eleven. That's the proper remedy, not getting violent and recklessly causing these injuries, which ultimately resulted in our victim's death. So I do believe that he's a danger to the community. These people had no connection. They didn't know each other. And this was, by all intents and purposes, a random act of violence that occurred in the evening hours at a public place at 7-Eleven. Secondly, I am concerned with regard to his ability to appear, Judge. While I will note that he has virtually no criminal history, I know that he has one DP out of North Carolina for carrying a concealed firearm. He does have a warrant from the 5th of August, 2024, out of North Carolina for attempting to buy a firearm from an undercover police officer. And I did speak to Mr. O'Connell about this, and I will put on the record, we did reach out to North Carolina because the warrant listed extradition only 100 miles. And they said the warrant is still active, but they will not be coming to get him because it's more than 100 miles. So I just wanted to put that on the record. But that gives me concern, Judge, that he has this history with firearms and an open warrant out of North Carolina. He's now going to be facing mandatory near a time with this manslaughter charge, and I am concerned about his failure to appear in the future for court dates, Your Honor. So with that, I submit, I leave to the discretion of the court, and thank you, Judge.
Thank you. Mr. O'Connell.
Thank you, Your Honor. Your Honor, I do take some exception to a representation made by Ms. McGee. She indicated, as we know, Your Honor saw, there's no audio here. Her saying, my client saying to the victim, hit me, or trying to antagonize him. There's no facts to substantiate that or support that, so I would ask Your Honor to disregard that. Your Honor, we're not here to try the case. We're here to determine whether or not there's any reasonable conditions that you can impose upon my client in order to release him while these charges are pending. You know, he has the support of his family here, that he was born and raised in New Jersey. His mother his parents did separate. His mother did move to North Carolina. He has spent time between her house in North Carolina and his father's house here. He's been gainfully employed at 7-Eleven, where his father also works, and has been working there since 2019. Since 2019, Judge, he's had no altercations or any interaction with law enforcement. We do know that he does have those misdemeanor charges or disorderly persons offense that arose out of South North Carolina. But Judge, it's from what I understand as to the misdemeanor, he had a lawfully possessed firearm. He didn't have the proper permit to have the gun wherever it was at the time he had interaction with police. Obviously, it's not dealt with as seriously in North Carolina or most of the South as it would be here in New Jersey. Judge, he is completely unaware of what the other charges out of that Ms. McGee has represented. I do note that it is on his NCIC, but it does limit it to a 100-mile extradition range, which, Judge, also makes me think, with my somewhat knowledge of the South, having some property and being a homeowner down there, that I think this also may be a misdemeanor type charge pending in North Carolina. In any event, Judge, he's not going to flee this jurisdiction to avoid these charges. Judge, our position here is that the victim in this case showed up late in the early morning hours into the 7-Eleven, walked in belligerent, was demanding free food, even though he had money on him. My client helped him, said to him, hey, listen, you can get 2 pieces of pizza and a Coke for $5.20. He helped ring him up with that. He was trying to be accommodating to him. As Your Honor saw, he began eating at the counter where other customers were attempting to check out. He asked them to please either step outside or move to the side so that people could get to the register. The victim in this case then became verbally aggressive and also physically aggressive. You can see that he reaches across the counter and smacks at my client. My client, Judge, then goes around the counter to escort that individual out. He wasn't going to start a fight. He wasn't going there to provoke a fight. He was going to escort the individual out of the store, at which point you see the victim goes to him. You see that in this case. He goes to the counter where he's at, and the altercation starts. Judge, my client had no intention to cause this type of injury. Hands were flying. His hands are up, and we'll deal with that at trial. But Judge, if we look at his score here, his failure to appear is a 2. I think that's only because of the nature of the charge, and there's some inherent risk of facing a nearer offense you might flee. But he has no history ever of not appearing for court. His new criminal activity is a 2. Again, Judge, he has a disorderly persons offense on his record. His entire time in New Jersey, he has not been arrested until this offense, and he's, I think it's 29 years old, right? 29 years old and living a law-abiding life. He has his family and his extended family and his family here in New Jersey to support him. I think, Judge, that you can safely, and as for danger to the community, Judge, I dispute that. He's he works the night shift, the overnight shift at the 7-Eleven on George Street, dealing with people who are out, other than law enforcement officers, people who are out in the early morning hours, and he's never had any altercations or any sort of physical interaction with anybody before this alleged incident, this incident. So, Judge, I don't think he's going to be a danger to the community. He hasn't been a danger for 29 years. Judge, he's not a risk to obstruct the process in here. This case is what it is. There's nothing that he can go out there and intimidate witnesses or tamper with evidence. We have the case. It's in. And Judge, again, I can't stress enough his ties to the community. So I think based on all of that, Judge, that Your Honor could release him. I understand that he is looking at nearer time. But again, was his conduct reckless or negligent? That's something maybe a jury's going to have to determine. Or was there self-defense here? So, Judge, I think you could release him. I would ask for level 2, but based on the nature of the charges, Judge, I would suggest level 3 on PML, and that you order that he remain living with his father, who is the gentleman second from the end. And their address, Judge, is Riverside Drive here in New Brunswick. That is where he's been residing, and his father has indicated he has no objection to him continuing to reside with him and working where he's been working. His father is also one of the managers at the 7-Eleven, and he is free to go back to work. So, Judge, while this case is pending and it may result in litigation, he should be able to stay on the street because he's not a risk to the community, he's not going to flee, and he's not going to tamper with this case. Thank you, Judge.
Thank you. This case comes before the court on the state's motion to detain Mr. Sanders Boyd. Probable cause was established by stipulation and proffer. The next step is to determine whether the state has demonstrated by clear and convincing evidence that there are no conditions that would assure community safety and his appearance in court. The public safety assessment provides guidance, and he scores a relatively low score with 2 out of 6 on each of the risk scales for failure to appear and the risk of new criminal activity. And the recommendation is that he not be released because of the nature of the charge. He's got the one charge for a reckless manslaughter that does give him substantial exposure to prison time if he is convicted. In terms of pending charges, he has none. He has no prior indictable convictions. He has the 3 misdemeanor convictions out of North Carolina that are not that remote. We're talking about a 2017, 2021, and 2023, and according to the proffer, there may be a warrant out of North Carolina related to another charge from 2024. And other than that, he has no history. The nature of this is clearly a violent crime with the most horrific and tragic results from what appears to have been an unintended killing of this person. The strength of the state's case, I would say, is moderate, despite the fact that it is captured on video. There are questions about provocation. There are questions about self-defense. According to the affidavit of probable cause, there is some indication that a witness said that the victim said, "I know what time you get off." And the witnesses do appear to indicate that Mr. Sanders Boyd was not the aggressor in the circumstances here. It is notable that the victim did have a sling on his arm, so the strength of the threat that the victim may have posed is questionable. But from watching the video, it does appear that there was a mutual fight, and that according to the witness statements, the victim may have been the aggressor here. Mr. Sanders Boyd has very strong family and community ties. I count 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 people here in my courtroom that came in to support him, including his father, with whom he resides. Having a job for 5 years is a good track record for a strong community tie. So he clearly has support in the community and with his family. In terms of his character, I'm advised that he called 911, that he may not have given the proper name, but according to the defense proffer, he did cooperate and give a detailed description of what happened to the police, which was recorded on body-worn camera. He didn't run from the scene or anything like that. He instead cooperated with the police. And in terms of failure to appear, there's no history of that, and exposure to extensive sentencing is not reason enough to make a finding that I'm clearly convinced that he won't appear in court. These strong community and family ties will assist in making sure that he appears in court. So based upon the totality of the circumstances, I am not clearly convinced that detention is necessary here. So I am going to release you, Mr. Sanders Boyd. You're going to have to follow certain conditions while your case is pending. I'll explain those to you now. You'll also get a written order when you leave the jail today. Make sure that you read it thoroughly, because everything I'm telling you will be in writing. And you have to follow these conditions, because if you violate them, you could end up back in the jail, all right? All right, you're going to be on level 3 monitoring. Level 3 monitoring is going to require that you report to pretrial services every week. That will start with a telephone call tomorrow afternoon. The specific date, time, and phone number that you need to call will be included in the order that you get when you leave the jail. Usually you're going to find that on page 5, the last page of the order, so read it to the end. All right. Your pretrial services officer will give you further instructions, but the reporting is going to alternate between virtual reporting and the telephone call. Okay? And you have to show up for court. You do have a court date for a pre-indictment conference on December 2nd at 9 a.m. And I don't know, Ms. McGee, if you're intending to present this to grand jury before that date in light of the nature of the charge.
I don't think so, Your Honor.
Okay.
This is going to be assigned to one of Judge Desai's assistant prosecutors in her courtroom. So
Okay.
Once I have that assignment made, I'll let Mr. O'Connell know.
Okay, so we should be able to have a pre-indictment conference and potentially
Yes, Judge.
even resolve the case at the early stages. So that date and time will also be included in the order that you get when you leave the jail. And we're going to get your contact information in a moment. If any of that changes, you need to let us know, because future court notices will be mailed to you. And if you miss if you don't tell us that you moved and you miss the court notice, then you would miss court, you'd be in violation. And we don't want that to happen. You need to show up to take care of this case. And you are not to possess any weapons. You're not to consume an excessive amount of alcohol or any unprescribed unlawful narcotics. Do you understand the conditions of your release? All right, and is the address start with?
Yes, sir.
Okay, and is that a house or an apartment?
It's in a house.
Okay, so just putting
What's
and the
it?
rest of the address gets the mail to you?
Yes.
Okay, and would you like to submit his phone number to the court via email?
I will, Judge.
And his email address?
I shall, Judge.
All right, please do that.
And Judge, I'd be remiss, and I apologize, I did not mention that his mother came up from North Carolina after work yesterday to be here this morning. So I apologize I didn't bring that up earlier, as well as the rest of his family from North Carolina.
All right, now, if there is this warrant out of North Carolina, I don't know that they're going to seek to hold him on that, but I will ROR him on that warrant, because otherwise he wouldn't be getting out today. But you would have to follow up with North Carolina to see what's going on there. And you may have to go down to North Carolina to address that. All right,
We'll work on attempting to resolve that, Judge, while
Okay.
this is pending. I'm going to advise him probably not to go within 100 miles of that county until we get some groundwork done on that first. So.
Well, I'm RORing him on that warrant, because otherwise our jail may not release him.
And I think Ms. McGee can, they have not filed a detainer on him as yet, and they've indicated they will not extradite.
Well, that's why I'm RORing him. If they were talking about extradition, then we'd have to deal with it in a different way. All right. Any questions, Mr. Sanders Boyd? All right. Do Mom or Dad have any questions? Okay. All right. Good luck to you. Thank
Thank
you.
you, Judge.
Keep the peace. Thank you, Katie. Let's go off the record. I'm going to go take a quick